Good morning, everybody. We are going to get started in a few moments here, just waiting on the rest of the registrants to log in. Very, very quickly, I just want to thank everybody for their presence today. Your participation in this CLE indicates to me that you care very, very deeply about the immigrant community in Tennessee. So I want to commend you for your interest, your empathy, and your hard work during these very uncertain times. If you're here for the free CLEs, I also want to welcome you. I hope by the end of this presentation, you'll have a new interest in the advocacy opportunities for the immigrant community, and that we can equip you with tools to assist them. All right. Having said that, a few housekeeping items. The first is that this is the first part of a two-part, I guess, series where our vision was that we would train attorneys on how to use powers of attorney in practice for immigrant families who are facing potential changes to their lives, whether that's through deportation or detention, and how the powers of attorney can assist them through that process. And so if you're not an attorney and you're logged in today, I don't know how useful this presentation will be for you. On the 23rd, we're going to have a presentation that's geared more toward organizations that interface with immigrant families. And that's where you come in. If you're an advocate, a non-attorney advocate or organization, I highly recommend that you attend the October 23rd webinar. That will explain how the logistics will work for interfacing with your immigrant constituents and getting them connected with attorneys who can assist them, whether that's through general legal advocacy in the immigrant field or through what you'll learn today, which is powers of attorney. So also some other housekeeping items. This is going to be recorded and I'll distribute it to all the participants after the webinar ends. So you do not need to record this. I ask that you simply take this all in, and we'll get you the slides, the handouts, and recording sent to you after this. Additionally, with that follow-up email with the slides and the recording will be a form for you to fill out. If you're looking for CLE credit, if you're an attorney licensed in Tennessee, what I'll need is your name and your bar numbers so that I can record your CLEs for credit. If I don't get those by a certain date, I won't be able to register your credit. So I just ask that you fill that out as soon as you can when we send it to you. Okay. And like I mentioned earlier, there's another session on the 23rd. If your organization has both a legal and advocacy part to it, then I also recommend that you attend that session, just so that you can understand sort of the logistics of how we kind of anticipated this operating. Again, we hope to train attorneys today on how to implement this POA in practice. And then the goal would be for immigrant interfacing organizations to refer their constituents to those attorneys to have these POAs filled out. All right. With that said, hi, my name is Josiah Mesra. I'm one of the attorneys at the Tennessee Justice Center. With me today, I also have Emily Jenkins, who's a staff attorney at TJC and the director of our Healthcare Justice Clinic. And Tarsila Crawford is with us. She's the Family Defense Counsel at the Tennessee Immigrant and Refugee Rights Coalition, TIRRC. Each of them will introduce themselves again when we get to their respective portions of today's presentation. So our agenda for today, we're going to talk about the background and the legal context for today's training. Obviously, there's a lot going on, and we're going to talk about how we can best serve our clients in these very uncertain times. With that said, we'll go in depth on powers of attorney for care of minor children, how to prepare powers of attorney in the clinic and community-based settings. And then something that Emily and I will expand upon more and is also mentioned in the handout that you will receive after today's training, other family preparedness considerations, specifically with respect to public benefits, something that we at TJC know a lot about, less so on immigration law. So why are we here today? Why are you here today? It's because we all recognize that there is a problem, not a potential problem, but a very real problem faced by our immigrant community members. And it's that nothing really is off the table in terms of actions against immigrant families. They're even like mixed eligibility household members, mixed status households, everybody is at risk of potential action by ICE, by the Department of Homeland Security. We just live in very uncertain times, and therefore it's best to be prepared for the worst case scenario. So who's at risk? And if you're an immigration attorney, bear with me. I know that you know these better than I do, but for those of you who are in attendance today that aren't immigration attorneys, we're just going to talk very briefly about the statuses that we're mostly concerned about in these times. And the first one is those who are considered undocumented. Now, there's a lot of conversation out there about what it means to be an immigrant with undocumented status. The dialogue is usually that they're an illegal immigrant, that they entered the country illegally, that any enforcement action against them is justified because of their quote unquote illegal status. But by and large, that's just not the case. Individuals who are undocumented very, very likely came in on legal status, whether that was through a parole status or another temporary status. What likely happened was that their status lapsed or it was removed by USCIS from eligibility to remain temporarily. So we see it in the news all the time that USCIS is continuing to remove TPS status for different countries. If those individuals who are on TPS then remain, they're considered undocumented. And we understand that there's a lot that goes into these sort of things rather than just a simple decision to remain unlawfully. There's financial considerations, there's family considerations, especially for families that have mixed status members. So maybe some are undocumented, but others are US citizens. Maybe some are undocumented, but others have lawful status. It's not a one trick, pony. It's a mixed bag. And so when you have a client who's coming to you, you need to understand that just because one client may have a certain status, whether that's undocumented or otherwise, that may not be true for the rest of the family, which complicates the next steps. We also need to consider those with asylee status. Those are individuals who are fleeing persecution, and they are granted the right to remain in the US for a certain amount of time. And in that time, they can transition to another status like lawful permanent resident. Those with parole status is another one that I think that people tend to confuse because the word parole is used in a criminal law context as well. And so when we talk about parolees, we're not talking about people who are in prison. We're talking about individuals who've been granted stay in the US because of an urgent situation, like an urgent humanitarian situation, or because of public interest in that individual's residence in the US. And lastly, we also need to consider lawful permanent residence. And this is generally the status that, a lot of families are trying to reach. They're trying to reach LPR status, which is also known as a green card. These individuals have more opportunities and rights than other immigrant statuses. Therefore, it is sort of the status that most families are trying to reach. We need, like I said earlier, we need to consider if you have a client who comes to you and you know their own individual status, we need to also document and be concerned with the other statuses in that family. This is especially important for purposes of public benefits. Someone who's undocumented is not eligible for public benefits, but someone who is of different status, LPR, US citizen, asylee who transitioned to LPR, they are eligible for public benefits. So knowing what the status is, not just of the individual that you're interfacing with, but of the rest of the household, is very important so that you know what you can do to assist them. And the population that we're concerned with for purposes of the powers of attorney, it tends to be that mixed or blended status family. So someone, usually the parents are on a status that's more in legal flux, maybe they're undocumented, they're at potential risk of deportation or detention. But because their children were born in the US or attained a certain legal status, they're not at that risk. And so there is a risk of those parents and children being separated. And it's that separation that we're especially concerned about and why we want to educate attorneys today on how to do these powers of attorney. So how can families prepare? And we'll talk more about this during the October 23rd session as well. But the first one that we want to talk about is making a child care plan. My colleague Emily will go into more depth on that. And then if you're an immigration attorney today, like Tarsila is, find out the family's immigration options. Maybe they haven't initiated the LPR application process. They need to get on that as soon as possible if they can. Maybe they're eligible for asylum status or refugee status. They should do their best to attempt to reach that status if they can. And then lastly, we want our clients to know their rights. Just because they're not US citizens doesn't mean that they don't have rights. They do. And knowing them, it can make the difference between an awful familial outcome or continued normalcy for that family. Having said all of that, I'm now going to pass it on to my colleague, Emily Jenkins.
Thank you, Josiah. As Josiah mentioned, I'm Emily Jenkins. I'm one of the staff attorneys here at TJC. And prior to coming to TJC, my work largely centered around the child welfare area, which is one of the reasons why I was grateful to TIRRC for partnering with us on this, because having had experience with the outcomes for children who do enter state custody through child welfare, I understand the critical importance of planning ahead and helping families equip themselves so that they can avoid a child unnecessarily coming into state custody. So why making a child care plan is so important? If you've followed the news in Tennessee or have had any interaction with our state child welfare system, you know that DCS is unquestionably overwhelmed. There are not enough placements for children in the state. Those placements tend to be sporadic. Children tend to cycle through multiple placements before they will obtain a more permanent housing situation. And we want to do whatever we can to prevent children ever entering into custody. If a child enters into custody, it's far more difficult for their family supports or community supports to then become the caretaker of that child. And so what we want to do is equip parents with the documents that they need to fill out in advance to help them understand what kind of information they need to make sure that the person who's agreed to be a temporary guardian, if they face a deportation or detention, what documents they need to provide to that person, and how to support the caretakers who are agreeing to take on at least temporary custody while their parents' legal status is sorted out. When you think about the things that planning ahead helps us avoid, it's a lot of really important things. I mean, the data on youth in foster care is not good. There was a recent study in Tennessee that looked at foster youth outcomes, and by age 21, 36% of children that have been in foster care in the state will have experienced incarceration. 31% will experience homelessness. Nearly 22% will be parents themselves by the time they exit custody, and only 16% are enrolled in post-secondary education. None of these are outcomes that we want for children in our state, but particularly for families with blended status, planning ahead can help us to avoid them entering a system that we know is broken. When you look at kinship placement, which when we say kinship, we're referring to family placement, but it also can be more loosely used to refer to placement with family, friends, or other community supports, church members. I've seen teachers take in children, whoever can be that trusted adult to provide stability to a child when their parent faces detention or deportation makes a real difference in the likelihood of them having a positive outcome. So when we look at what we get by having planned ahead, when children experience a loss of a parent and they're placed in a kinship placement, we minimize the trauma of that temporary loss of the parent in their day-to-day life. We increase the likelihood that the placement they receive when their parents are removed will be a more permanent long-term placement versus bouncing around from home to home in the state custody. We improve behavioral health and mental health outcomes for the children. We are promoting sibling ties because when you plan ahead and parents are able to select a guardian of their choice prior to detention or deportation, they're more likely to have their children placed together in one home, which, when you think about a child losing the day-to-day connection with their parent caregiver, having the familiarity of their siblings in the same home makes a real difference in their ability to deal with a pretty traumatic time in their lives. The other thing that's critical for these children is that by being able to select where the child goes, you assist the family in preserving the cultural and community connections. The children are usually able to stay in the school of origin. They're able to stay connected with, friends, family, church, all of the things that they lose when they go into foster care. A lot of the outcomes that we see from foster care is a result of losing those cultural and community connections that give kids the limited stability they can get during a really tumultuous time in their life. When we look at selecting a caregiver, and Tarsila will go over that process in a moment, we do want to make sure that whoever is accepting the role of the temporary guardian of the child is fully equipped to support the child in the best way possible. That includes providing the caregiver with the copy of the power of attorney and documents related to the child that Tarsila will be discussing how to create, and ensuring the caregiver is aware of public benefits that the child is already enrolled in or entitled to be enrolled in. As Josiah mentioned, a lot of these families are blended status families. So you may have a non-citizen parent who gives birth to a child in the U.S. who is a U.S. citizen. That child may already be enrolled in SNAP, in TennCare, may be receiving free and reduced meals through the free and reduced meal programs at school. The family may be enrolled in WIC benefits. You want to make sure that whoever is taking on the caregiving responsibilities for that child knows what programs they're currently enrolled in. If you have an enrollment card, an insurance card, other documents related to those programs, provide copies of those to the caregiver. And then make sure that the caregiver is aware of programs they may be eligible for. One of the documents that you'll receive as a follow-up to this is an addendum that we've created that helps to explain to caregivers who are taking in a child what programs the citizen child may be eligible for after a parent is detained or removed. So Tennessee Justice Center is here to support you in your ability to support these families. So we provide technical assistance for attorneys and for caregivers. We can help you with navigating the public benefits program for TennCare, SNAP, and WIC. You can reach out to us on our website. There's a free help button where you can open a case inquiry, or you can feel free to contact myself or Josiah directly through our contact information that's provided at the end of the slides. We are happy to support you, and we appreciate your willingness to look for ways to support these families and to help provide the stability that really can make a difference to children that are experiencing extreme hardship when there's a change in their parents' immigration status. So with that, I'm going to turn it over to our friends at TIRRC and to Tarsila to go into more depth about what the actual documents are that need to be created and what you as an attorney can do to support these families.
Thank you, Emily. That was really important information that you provided. I took some notes about what you said, and I wanted to reiterate some of the things that you were saying before I get into my presentation. I think a lot of us feel very powerless to help people, to help the immigration community, but we as attorneys are never powerless to help others. And this process of understanding how to help through a very simple form, the power of attorney for care of minor children, can help attorneys feel more powerful to help the immigration community, and it can help the immigrants feel more powerful to control what happens to their children. We are very concerned, many of us, and this is part of the reason why we're putting on this presentation. I want to thank Tennessee Justice Center for promoting this, putting it together, and doing all the logistical work. And I want to reiterate what Emily said about stabilizing children during difficult times. And that's really what this is all about, is to protect children, maintain their stability, allow them to have benefits they're already entitled to under the law if they are United States citizens, and help parents prepare. So first, we're going to look at demographic and legal context at the next slide, please. According to a survey done about 3 years ago about families in Tennessee, there are more than 383,000 immigrants living in Tennessee, and I'm sure that in the last 3 years, there's even more than that. This population includes a diverse amount of people with different statuses, including naturalized citizens, lawful permanent residents, and others who have a range of immigration statuses that Josiah was talking about earlier in the presentation. And there are approximately 91,000 US citizens who live in Tennessee with at least one undocumented family member. And this is the critical point that we're making about what we call mixed status families. Many people have a false idea of immigrants and how they come and cross the border illegally and live in pockets with other illegal people, which we don't really call them illegals, we call them undocumented. But we have mixed status families, which means that perhaps a parent is a naturalized US citizen or has a visa or is a legal permanent resident, and the children are US citizens, or perhaps we have undocumented parents and US citizen children. And that is why this is a risky situation for families, because 58,000 US citizen children may reside with a parent who is undocumented. And this puts US citizen children and mixed status families at risk of losing a parent to detention or deportation, in the very aggressive ICE sweeps that are happening across the country. If you go to the next slide, please. So the legal background for this, since we are at a CLE, we have to get into the legal part of it. Children born in the United States are US citizens, regardless of the immigration status of their parents. And some children born outside of the United States under certain conditions can be considered US citizens as well. And yes, we will all get CLE credit for attending today. We can send you that information afterwards. Immigrant parents have constitutionally protected parental rights, and that's regardless of their immigration status. As we know, there's a lot of false information being promoted about immigrants, and at this time, immigrant children born to immigrants that were born in the United States are US citizens, and immigrant people located in the United States and their children have constitutionally protected rights. And one of those is parental rights. In general, in family law matters, the immigration status of a parent should not affect a court's custody determination in cases like custody and divorce. The court does a best interest analysis, as many family law attorneys know, and a person's legal or undocumented status does not come into question when we are talking about custody determinations. Next slide, please. And so today I'm talking specifically about the powers of attorney for care of minor children, what they are and what they are not. And just to kind of get to the point regarding that question, if you are a family law attorney, you know that we need custody orders and parenting plans and final decrees of divorce to determine who has custody of a child under the law. A power of attorney does not give custody, and I'll discuss that a little more in detail, but I think it's important to say that at the top for all attorneys who may not have a family law background. Many of you know that I've been practicing family law. I'm in my 18th year of practicing family law at Widrig Law, and I have taken this part-time role with TIRRC in order to help provide family law information to the immigrant community, advocates, and attorneys. And part of that is helping people understand that a power of attorney is a designation for a temporary caregiver in the event that a parent cannot serve their parental duties. And one of those things that we're doing is filling out power of attorney forms in this time of hardship or incarceration or detention. And we do those forms prior to incarceration, detention, or deportation. The power of attorney form is in effect for as long as the parent wants it to be in effect. It doesn't expire in any period of time. It can be terminated by court order, or any parent with legal custody can terminate the power of attorney form, and it must be revoked in writing. Next slide, please. As I was talking about, this is not a custody order. It is used to help parents prepare in the event of detention or deportation. It may be a sudden event, and they need somebody to pick the kids up from school, take them to school, put a roof over their head, feed them, take them to their extracurricular activities while they're dealing with their immigration law issues. It's also important to have a power of attorney form filled out, because if the Department of Services does get involved with children who are detained, whose parents are detained or deported, it could help show DCS and the court the parent's intent on who should take care of the children in their absence. I will say that I'm not aware of whether the power of attorney form has really been tested in litigation or tested in terms of the refusal of schools or medical providers or extracurricular activity providers. It hasn't really been tested if those providers will reject a power of attorney form. And so that remains to be seen. What I'm advising parents is to fill them out and have them ready, and then have an attorney that you know who to call, for the caregiver to call if they're having trouble with using the forms for school enrollment, etc. Okay, next slide. So in preparing the power of attorney forms, it's very helpful that the state of Tennessee already has a form, and you can find it on the state of Tennessee website, and I think we're going to provide that in the materials as well. There's already a form that if properly filled out, completely filled out, and follows all the guidelines for being filled out, then it is universally accepted in Tennessee as a form designating the caregiver to have the rights of the parent while the parent is not available. However, there are some provisions that must be filled out. It has to be signed by both parents and the designated caregiver. The caregiver must initial certain parts and sign as well. If one parent is not available to sign, the other parent must explain their availability. Within the form, there's a section to explain. So for example, this comes up when you have one parent who has custody of the child, and the other parent does not participate, has not been legitimized, does not pay child support, and is not in contact with the children. So the parent with custody would fill out that they are the only one signing. The custodial parent is signing the power of attorney form. The other parent is not available because they don't communicate, don't visit, and don't provide for the child. And then you actually are supposed to mail, in certain circumstances, mail a copy of the power of attorney by certified mail to the last known address of the other parent. The parent and caregiver signatures must be notarized, or you can have two witnesses sign as witnesses to the signing of the form. The caregiver should retain the original version, so that if the parents are detained, the caregiver has the original, and then the parents keep copies. You should also have extra copies to provide to medical providers, school and education providers, and extracurricular activity providers. And the power of attorney does not go into effect until the triggering event occurs. And the triggering event occurs when the parent is detained or deported. If you are preparing them for immigrant community members, it can also be incapacity of the parent, or other provisions that you can fill out. And there is a Spanish version translated that is acceptable, but I advise people to have these filled out in English and then provide a Spanish version as a copy to parents and caregivers so they understand. Next slide, please. So considerations for power of attorney clinics, if you want to put on one of these clinics or if you want to volunteer in one, we're going to talk a little bit about the logistics of that. And TIRRC has done several of those. There's lots of organizations in Nashville and in other areas of Tennessee that are doing power of attorney clinics. One thing that I will probably reiterate by the end of this presentation is the need for volunteer attorneys, especially family law attorneys, to make themselves available for power of attorney clinics, and also for consultation with people who may, with caregivers who may need to use a power of attorney form. And generally, family law attorneys volunteer for referrals for pro bono cases where immigrant families are impacted by family law related issues where a parent is detained or deported. So we'll ask for your participation on a lawyer referral list at the end of the presentation. Next slide, please. So ethical considerations in power of attorney clinics. It's important to involve an attorney, ideally a family law attorney, to be on site or available for questions. A lot of times questions are coming up in that section about whether both parents have custody or not, and where the non-custodial parent is and how to provide them notice and how to explain that in the form. you also need to ensure that clinic organizers and staff understand the legal significance of power of attorneys and give them a little bit of training, and also avoid unauthorized practice of law, avoid the staff and organizers from giving legal advice, and ask the attorney to give that advice. You also need to think through and take steps to protect the confidentiality and safety of individuals who participate in clinics. And this is done by maybe not promoting the address and location of the event ahead of time, and just vetting people who want to participate and giving them the address before the date of the event. Next slide, please. So logistical considerations that we've done at TIRRC prior to power of attorney clinics is to pre-screen people, and basically what I call vetting people before the day of the clinic. It makes it much more efficient. It can be resource intensive prior to the clinic, but it helps it run more smoothly. You should remind families that the caregiver should also attend the clinic because they need to review and sign. And that's very important because if the caregiver does not sign, then the power of attorney form cannot be used. So if the caregiver cannot attend the clinic with the parents, you need to make it very clear that the caregiver needs to sign after the clinic in order for the power of attorney to be effective. You should have access to a copier so that you can copy the power of attorney forms for people. And you can access the power of attorney form online, as well as the Spanish version. And I have the PDF link there for you. And I think it's in the chat as well. Okay, next slide. So for what we call family preparedness, which Josiah and Emily also touched on, there are some considerations that we recommend for our mixed status family, immigrant families. Next slide, please. It's important to obtain passports for U.S. citizen children. And this can be a little bit complicated when the parents are not together or don't agree to the passport being issued. But you have to look at the form for the application for the U.S. passport to help advise your clients on how to deal with that. If one parent cannot go to the appointment to get the passport, there may be additional steps required, including getting a court order. And that's why family law attorneys are needed to volunteer, because sometimes a custodial mother may want to get her children their U.S. passport, and the father is maybe not participating, and there may need to be a court order for the mother to do that. If one parent has custody, they may need to show proof of their sole custody of the children if they already have that. Next slide, please. So other elements of family preparedness is to have a document checklist, emergency contact list, financial preparedness, consider financial power of attorneys. And we wrote with caution because you need to really have an experienced attorney do a financial power of attorney because those are more complex than the power of attorney for care of minor children. If you go to TIRRC's website, you will find a lot of helpful information for your immigrant community members. And there are Know Your Rights packets. There's a power of attorney flyer that we've created at TIRRC to give information about what the power of attorney form is. And I encourage attorneys who work with immigrants to look at this forms and the other forms on our website on tnimmigrant.org. I think a lot of family law attorneys, maybe if they don't speak Spanish or another language, they feel like they're not really available for the immigrant community. But I think if you've practiced family law for any period of time in Nashville and really anywhere in Tennessee, you have come in contact with immigrant families, and you can be a resource for them and give them information that they might not already know about. So if you go to tnimmigrant.org and find the resource page, you'll find documentation that you can provide to your clients. And you might say, well, I'm not an immigrant attorney, but here are some legal information that may be helpful to you. So you have an opportunity as attorneys to connect people to resources at TJC for benefits and at TIRRC for immigration legal questions. And attorneys have a very important role in society to help people who may not have the resources or knowledge to help themselves. And if you're interested in being on a volunteer list for attorneys, I can explain more to you through email, and you can email me at tarsila@tnimmigrant.org. We'll make sure you have that email later as well. And we're asking for attorneys to volunteer to be on a referral list for immigrant families who may have questions about anything related to family law. And some of that is help with passports, some of that is after detention of the parent, some of that is caregiver questions. We want to connect people with pro bono family law attorneys. It may not mean that you take a case, it means that you assist these families if a parent is detained or deported. This form here, this slide that we're showing you now, is TIRRC's Power of Attorney form. That's also going to be in the materials and available on our website for people to look at and share with their clients. There's an English and Spanish version. And that's it for the end of my presentation. I think we'll wrap it up here in a few minutes and do a question portion.
Thank you, Tarsila. So at this time, if you have questions, if you could please use the Q&A feature to submit those, and we will do our best to answer them. Right off the bat, I know that there is likely some questions about how HR1 plays into this. HR1 being the OBBB, the act that was passed this past summer by Congress. And the answer is that HR1 does affect our immigrant clients, specifically with respect to eligibility for public benefits. I'm not going to get too far into the weeds, but what you do need to know is that eligibility for public benefits has been severely narrowed by HR1. If you had a client who was a refugee or an asylee, they were previously eligible for public benefits immediately upon attaining that status. There was no waiting period. They could get SNAP or Medicaid immediately upon getting refugee or asylee status. The understanding being that these individuals were in dire need of those types of benefits because of the persecution they were fleeing or due to their family circumstances. That's no longer the case. This administration has decided that refugees and asylees are no longer a public interest to us. We don't really want to concern ourselves with assisting them in their dire circumstances. They've been removed from eligibility for public benefits. The statuses that are eligible are only lawful permanent residents, Cuban and Haitian entrants, and COFA migrants, COFA being the Compact of Free Association, immigrants from Palau, Marshall Islands, and Micronesia. And that is it. This is a very narrow group. So we're likely going to encounter a lot of questions from clients who who need nutrition assistance, who need healthcare, and we may have to deliver some bad news to them. One quirk about this that I do want clients to be, for you to be aware of and for our clients is that if they transitioned from refugee, asylee, or another humanitarian status to lawful permanent resident, they are eligible for public benefits. And unlike clients who are on LPR and they did not transition from a humanitarian status, they are not subject to what we call the 5-year bar, which is a 5-year period of ineligibility for public benefits. So classically, if you attain lawful permanent resident status and you weren't a humanitarian status before that, you had to wait 5 years before you can start using public benefits. That's not the case for immigrants who transition from a humanitarian status to lawful permanent resident. They can start receiving public benefits as soon as they reach that status. I hope that made it clear as mud for everybody. If you have questions, please, please, please reach out to us. We're happy to answer those. I see a question from an anonymous attendee who said, is it ever appropriate for someone without a law background, a legal background, to assist a family in filling out and submitting the power of attorney form? For example, if a family doesn't appear to have access to a legal clinic or individual attorney, or does the possibility of errors outweigh concerns about a time-sensitive situation? That's a good question. I'm going to leave that to Tarsila to answer.
Yes. Sure. So the power of attorney form is already approved by the state of Tennessee as an acceptable form, and it is valid as long as it's filled out completely. So the concern would be a non-attorney filling out the form with a family. There's no prohibition on doing that. Families can fill out these forms by themselves without lawyers. I'm sure they've already done that for years up until we had this immigration law crisis. Um, you do have to worry about the unauthorized practice of law, so you cannot give legal advice. But that's why organizations like TIRRC and other organizations are training advocates to understand these power of attorney forms. And that's why I always recommend that there is a family law attorney involved in the legal clinics. If you can't have a legal clinic setting or an individual attorney setting, then each person has to make their own individual choice about helping families fill these out. As far as I know, it does not invalidate a form if an attorney didn't fill it out. So I think you kind of have to use your own individual discretion on those types of assistance that non-attorneys provide.
Thank you, Tarsila. Another question. I see Johnny's question in the chat, in the Q&A, but I want to address Amanda Jelks' question, which is, does the POA for minor child need to be filed somewhere upon completion or once it's activated due to the activating event, such as deportation?
Does the power of attorney need to be filed anywhere? No, it does not get filed necessarily. The power of attorney original should be kept with the caregiver. And then the copies of that power of attorney form that is completed can be provided to the school, educational institutions, medical providers, extracurricular providers. The copies are given to anyone that the caregiver interacts with on behalf of the child as the power of attorney for the parents. It would probably get filed maybe in a custody case or a DCS removal case. But when you complete the form, there's no place to file. You just keep the original with the caregiver and have copies.
Another question. This one's from my friend Johnny Epstein. In addition to POAs for caregiving and financial matters, does it make sense to have families fill out POAs for anything else, like medical decisions?
That's a good question. There are, I believe that there are forms for medical decision making that the state of Tennessee already makes available. I think we have, I'm having,
Advanced directives?
yes, exactly. All people really need to do that to ensure that their wishes are carried out. And so, yes, you could do power of attorneys for medical issues as well. I mentioned in my presentation about financial matters. Those may be important too. Power of attorneys for financial matters, but you need to find somebody who regularly fills those out and can advise you about bank accounts, homes, and those types of things.
The other thing I would add is that if the child is TennCare eligible, we would recommend that the that the parent fill out the TennCare authorized representative form and list the caregiver as an authorized representative for the child, because that's what you're going to need if there's an issue with the child receiving some service that's Medicaid funded. The insurance company is going to require an authorized representative form to then talk to the caregiver about in-network service providers or issues with approving particular services. So we would also recommend that they complete a TennCare auth rep form.
And these will, Johnny, that was a good question. Some of this will also be elaborated upon in the handout that you'll receive in the email, especially as it regards access to public benefits. There are steps that you need to go through, like Emily talked about. One of those is authorized representative forms that you may need to fill out too. And one last question that I see, and this is probably for you, Tarcia. In terms of custody, does that apply if the parent seeks visitation?
I'm not sure if I understand that question completely. In terms of custody, does that apply if the parent seeks visitation? When you have power of attorneys filled out by one parent, due to the unavailability of the second parent, you need to explain why the second parent is not signing. And sometimes that's because the second parent hasn't been what we call legitimized under Tennessee law. And these are complex family law issues that we could talk about probably for another hour. But basically, when a woman has a baby and she's not married, the mother is the custodian or primary parent of that child. And the father may need to take some steps to become legitimized or have his rights preserved. So that's often what we deal with in power of attorney clinic settings, is that the mother has the children, she's not married, she can sign the power of attorney form, and she needs to explain whether the father has any involvement or not. And that is better to be as detailed as possible within the form. If the father is actively trying to get visitation and has been legitimized, then he does have rights that have to be preserved, and that's why he is supposed to be sent a copy. And it's not just, it could be the reverse too. The father could have a court order that he's the primary parent and custodian of the children, and then the mother would need to get notice. But there's lots of family law considerations that come up afterwards, which is why I kind of got involved with power of attorney clinics years ago, because sometimes one parent is filling it out, but there is another parent available. And so you have to have conversations with people during clinics or consultations about whether, if the mother is detained, would the father then get custody of the children or be available to take care of the children, even if the parents are estranged or the father is estranged. So, those considerations are why family law attorneys have to be involved. And I know that's kind of not what this person asked, but you need to have a family law attorney on call during power of attorney fill out if you're not a family law attorney filling it out. I also want to reiterate that we do need volunteer attorneys. I have a list of about 15 attorneys already who have volunteered to be on a family law referral list. And I am managing those referrals through TIRRC. So what happens is we get calls on our resource line for people looking for help with family law related questions. So if you're on our family law referral list, you may just need to answer one question for a family or answer an email, or we may ask you to fill out a power of attorney form with a family, or we may ask you if you can help a caregiver with an issue related to the power of attorney form. And so we would love for more attorneys to volunteer. We haven't had to activate our referral list too much lately, but I'm trying to build up this form in all areas of Tennessee in East, West, and Middle in the event that we, unfortunately, in the event that we do get a lot of children's stability being affected by parents' detention or deportation. So you can email me at tarsila@tnimmigrant.org, and we'll make sure you have that email address in the materials and communications that we send after the CLE.
Thank you, Tarsila. And as a reminder, today's training was free. You know, what we ask in return is that you do consider signing up for that referral list. You may not think that you're qualified or capable. I promise that you are, especially in light of today's training. And with that said, we have a follow-up webinar on the 23rd. This one is geared more toward, like I said, immigrant interfacing organizations. So community organizations, churches, anyone who, you know, has a pulse on the immigrant community and can communicate with them in a secure way. We want to give them instructions on how to refer their clients to that referral list so that we can get them the services that they need. I do see one last question, actually, or a couple of questions. Do there appear to be new concerns that the legal community is addressing due to the Friday announcement last week, the one that impacts unaccompanied children? Tarsila, I didn't read that announcement in depth. Do you have any commentary on that?
I'm not sure what that's referring to.
I think it, I
Go
think
ahead,
it may
Emily.
be referring to the announcement of the program where they were offering cash rewards to children who self-deport. I'm
I
assuming
don't
that's the announcement that I saw on Friday.
cash rewards to children that self-deport.
Yes, so the unaccompanied minors, if they agree to self-deport, then it's I think I saw reported between $1,500 and $2,500 cash benefit to the child to accept
So
self-deportation.
we do have these groups of children throughout the United States that are unaccompanied, that come from another country and cross the border and most of them are attempting to get asylum and they're unaccompanied, meaning they don't have a parent with them. That's a different group than what we're talking about here. And really those accompanied children are probably the most vulnerable that we have in family and immigration law and family law considerations. So there are organizations that attorneys can volunteer with and help those unaccompanied minors. And you could, if anybody wants to get involved with that, they can email me as well. But you can find organizations that need volunteer attorneys for unaccompanied children. What we're talking about here is caregivers and parents who might need help taking care of children.
All right. I think that that's all the time that we have today. I do want to thank everybody for their attendance today. Like I said, your presence today indicates to me that you're someone that cares deeply about this community. If you didn't before we started, I hope that you do now and that you answer the call to action and sign up to be a referral attorney. If you need our contact information, that's listed there. If you have any questions at all, please feel free to reach out to us. For public benefits questions, where TJC is likely your point of contact, anything dealing with immigration or family law or the POA itself, please reach out to Tarsila. Any final thoughts?
I'll just add one last thing, call to action, which is that, you know, even if you're not able to follow up and do some of the work with the attorneys and doing the POAs, as nonprofits, I'm sure TIRRC joins us in saying, please like, share, follow all of our social media posts. If you are able to contribute to our organizations, it's hard times out there for all nonprofits, and certainly the work is increasing while funding decreases rapidly. So we appreciate your support. If you have any questions that follow up after this, and if you have questions unrelated to immigration but related to public benefits, TJC is always here to help, and we would appreciate you joining us in our mission.
Yep.
Thank you.
Thank you. You should receive a follow-up email by the end of tomorrow with the slides, a recording, and the handouts, as well as the form to fill out for CLE credits. Please fill that out as soon as you can. and I will process those credits as soon as I can. Thank you.
Thank you.